May I please, your lordship? Lordship, 482 application, my lordship. This allegation under 296 BNSS, along with section 31R and 31S of the SC Act, my lordship.
The ST Act anticipatory bail is there.
My lordship, in certain, yes, prima facie, if the case is not made out, then there is no bar in granting anticipatory bail.
There will be required, lordship.
My lordship here, lordship may be pleased to peruse Annexa 1, page 15. Petitioner number 1, he is the my lordship.
So where is the FIR?
Annexa 1, page 15, my lordship. My lordship, the FI is at page 15. This is a counterblast.
What is TMPK?
This is missing organization, my lordship. It is Takam Missing Porin Kebang, TMPK. All Missing Students Union, my lord. This is a counterblast of my FIR and my representation before the DC. In the name of flood, they were collecting money, 500, 300, 200, by demanding money. I being the lessee of the market, and the petitioner number 2 with the member of the Ansulik Panchayat requested them not to do so, as many of the persons has already contributed. And when some vendors did not wanted to pay money, then one of the person, knowing my lordship, one of the another person, he has stated in a different manner. And thereafter, this picture has been taken out in a different way, my lordship. My lordship may kindly be pleased to peruse, my lordship, page 30 and page 33. I have filed representation against them. I have filed an FI against them. And thereafter, counterblast, this FI has been made, my lordship. And my representation and my FIR must prior to this FIR, my lordship. I am the lessee, my lordship, and I have annexed the document also. At page 28. In the name of flood relief, my lordship. Already, most of the vendors, my lordship, there is a small bazaar, my lordship. So most of the vendors have paid voluntarily, and even the petitioners have also. And thereafter, they came in for 200, 300, 500. And when some objected to it, a shuffle took place and we stopped it. And thereafter, on regard to that, my lordship may be pleased to peruse page 28 and page 30. I have filed a representation informing the co-district commissioner along with all the officers. Page 30, I have lodged an FIR also, my lordship, against this incident. And thereafter, my lordship, the instant FIR is filed, my lordship. (28), my lordship, may be pleased to peruse. Page 28 is that I am the present lessee, my lordship. And page 30 is my representation on 29/7/2026 before the co-district commissioner, and a copy of which was also been forwarded to CO, co-district police superintendent, executive officer, and secretary Gulaghat, my lordship. And my lordship may be pleased to peruse page 33 on 2/8/2026. I have also FIR, my lordship.
What is section 3?
3(1), my lordship.
SC/ST Act?
Yes, my lordship. 3(1).
SC/ST.
P1R, my lordship, may I read?
Yes.
Intentionally insult or intimates with intent to humiliate a member of a scheduled caste or a scheduled tribe in any place within public place, my lordship. And his punishment is not less than 6 months, but which may extend to 5 years with fine. And 31S is, my lordship, abuse any member of a scheduled caste or a scheduled tribe by caste, name in any place within public views. My lord, punishment is same, not less than 6 months, and which may extend to 5 years, my lordship.
The bar. There is an exception, lordship, that is there.
Mhm.
There is a bar, lordship, to anticipatory bail subject to the exception, lordship. Lordship will have to peruse the case diary and see if sections are meted out.
My lordship, here, My lordship, we prima facie, my lordship, it has been stated, but if prima facie case is made out, there is no bar, my lordship. Here, my lordship, I was the person who has informed the commissioner along with Superintendent Police months prior. I have lost FI. Thereafter counterblast, this has been made. And the allegation is that, my lordship, actually, we have already given for flat relief, most of the vendors. And it's not possible for poor vendors to give 200, 300, 500, my lordship. Again, for the second or third time. And when this was stopped, thereafter, this allegation was made, my lordship. And it has been taken to a different political picture, my lordship. My lordship, we will cooperate with the investigation, my lordship. The FI, it has been stated that I am not even the lessee, so I have annexed even the document. I am the lessee. And petitioner number 2 is a member of the Anchalik Panchayat, along with the president.
Those are different things on marriage. We
Yes, my
are
lord.
primarily concerned with
The,
whether any case under the act is made out from the FIR.
my lordship.
Page 17, Lordship.
Hmm?
Page 17. There that remark, Lordship.
What is in the vernacular?
May I read, my lordship?
Yes, that part. Telling of husband and
Yes.
that part.
অতি দুখেৰে আপোনাক জনাও যে আটাইকেইটা সংগঠন সংবাদ মেলৰ প্ৰত্যুত্তৰ দিবলৈ গৈ বজাৰখনৰ এটা অংশ মিচিং মানুহখিনিক সাজপানী গাহৰিৰ ৰুটি বিক্ৰী কৰিবলৈ এৰি দিয়া হৈছে বুলি কোৱাৰ লগতে তেওঁলোকৰ ল'ৰা ছোৱালীয়ে মদ বিক্ৰী কৰিয়ে পঢ়া শুনা খৰচ উলিওৱাৰ লগতে জীৱন নিৰ্বাহ কৰি আছে বুলি ৰাজহুৱাভাৱে ছ'চিয়েল মিডিয়াত ব্যক্ত কৰিছে। And with regard to this statement, my lordship, actually, my lordship, video is there in my hand, but since that cannot be made a part of this, I am willing even to write the exact language of the video that has been telecasted, my lordship. This is not the language, my lordship. At the end, my lordship, this first.
You could have given a transcription.
Yes, my lordship, they have. My lordship, in that, can it be matter be fixed tomorrow? I will write.
All right.
Then I will write.
Give a
exactly-
transcription of the video.
Yes, my lordship. The matter may be fixed on Friday, my lordship, because affidavit has to be done. I have to call for them. Friday, my lordship, I'll exactly file the transaction.
Otherwise, we could have called for the CD.
No, my lordship, it will not
If it
reach
is
by
called
Friday.
on Monday also, Lordship. I
No,
can
no,
call
my
it.
lordship, it will not reach them. My lordship, may I try on Friday for that?
All right. No, we are saying since we are waiting till Friday, we can call for the CD also.
If Friday, my brother can bring,
Or at least till Monday, you can have a chance.
then yes, my lordship,
All right, you give your version and we'll take up with the CD. So call for the CD, list the matter again on Monday, okay? Learned counsel for the petitioner may submit transcript of the video of the statements
Right.
made by the petitioner.
oblige, my lordship.
For equity application, Lordship. The petitioner happens to be the owner of the tract, and Lordship has already dealt with the affair, Lordship, that is at page 14, Lordship. And I have annexed his registration certificate at annexure 1, Lordship, at page 13, Lordship. Lordship, here 7 of his act is bailable, and other since other sections are non-bailable, petitioner is
What is the allegation?
Lordship. Some rise back.
TDS rise, yes.
And all documents already been annexed with the application, and the owner whose rise this honorable court has already given the privilege of PRS bail, Lordship. Now, Lordship, the purpose of approaching this honorable court, because Lordship, this petitioner, he filed an application of GMA, but he could not produce the this document before the concerned authority on the apprehension that he will be detained in custody. That is why, Lordship, this application being filed on apprehension. He's ready to cooperate. He's ready to submit the document, register his registration certificate and other documents, Lordship. May I pray, Lordship, and the privilege of arrest trail. The commercial vehicle, Lordship. Caesar.
I think the documents matched with the truck registration number.
Yes, Lordship. Yes, Lordship. Yes. The affair, in affair, Lordship.
This PDF rice was in the earlier case, this PDF rice was transported, that was
Yes.
intercepted.
Yes.
But the documents showed that it was purchased during e-auction and transport. That truck number is also mentioned in the document. So that is why he was granted. It is fixed for CD on, what happened on 10th?
It is extended, Lordship, for further day.
CD not received. Third learned counsel for the petition. Third learned additional. Page 20, okay? MS para 1, 2, 3. Then 4, the petitioner is the owner of the truck. Hearing registration number. What is the registration number? A01 KC 0792C, in which the alleged illegal consignment of PDS rice was being transported. Full stop. The by order dated 22/07/2026, the in AB 1637 of 26, the owner of the consignment of PDS rice was granted interim pre-arrest bail upon perusal of the documents connected to the aforesaid consignment. The aforesaid case is fixed on. When is the next date of that case?
Lordship, I'll give the date.
So and so for CD. Hence, having regard to the above para 6, okay. Is the matter in on? We'll give the date. Read date to side go. AB 1637 of 2026. 1637 of 2026.
Lordship, he will appear.
Yes, 10 days.
Obliged.
May I please your worship? I am appearing on behalf of A.A.R. Karim. My senior has been suffering from viral fever. Kindly may pass over the matter for the day.
Yes, Mr. Guy.
I have no objection, but on earlier occasion, they took time to file an objection. But as on date, they did not file. If they will file, then they will file within the time. Otherwise, the matter will be hard.
Mr. D.A. submitted on behalf of the respondent that learned counsel appearing for the respondent is suffering from viral fever. Adjournment has been prayed for. Objection has been filed till date. is the matter again on further opportunity of granting of filing objections shall be granted if the same is not filed before the
Obliged.
Obliged.
Lordship, kindly pass over for time being, Lordship.
For two one. For respondents at last.
and appears for the petitioner, Learned Counsel. The respondent is present. List again.
May I please? Last present lordship TCR has been called for.
Received. Yes.
For washing of affair lordship. Subsequently, charge sheet has been filed. Lordship.
Respondent number 2 is also there. Lordship.
It was present in last day. Here is here. Lordship, kindly present the affair first. Lordship.
Who is for respondent number 2? Huh? Item 19.
It was present in last occasion.
The order is there.
Yes.
Huh?
Name is shown, Lordship.
The order is there.
No. Which says there.
Trial is going on.
Yes, no, I has
The
applied
charge
for
sheet has just been submitted.
Yes.
lordship. After filing of this petition, lordship, charge sheet has filed. Lordship, basically, it's a civil in nature, lordship. There has been
Again,
agree-
after hearing you, after some time, he will come. He's come, I think.
is coming.
Yes.
So basically, in 2020, lordship, between this petitioner and the informant and the respondent, executed an agreement for land of shale. This land was from the district of Nagaon Raha. 1 kata 5 lakhs a land, and total consideration is 5 lakhs 62, and they have paid to 1 lakh 1 lakh 50 as an advance amount. And later on, it is mentioned in our agreement. Agreement is page 15, lordship, in my petition.
Yes, what is mentioned?
Page 15, annexure 2, lordship. They had paid an advance amount 1 lakh 50 to the first party. And according to the agreement, lordship, be it mentioned here, that 50% of balance amount is required to be paid by the third party. Third party is the respondent number 1. Respondent is only one respondent here. Within 1 month from the today to the first party, then to the second party will apply for the sale permission by giving relevant documents. That was not happened, lordship, and there is no notice has been given, no such things has been happened. And after repeated request, lordship, I have refund their 1 lakh 25,000. FIR is page 14, lordship. Vocabulary person, the Assamese person, lordship.
Yes,
May I read the Assamese person, lordship?
yes, read.
Yes. বিনীত নিবেদন এই যে আজিৰ পৰা প্ৰায় 4-5 বছৰ আগতে ওপৰত উল্লেখনীয় পদকীয় মোক মাটি বিক্ৰী কৰাৰ প্ৰলোভন দি মোৰ পৰা নগদ 4,75,000 টকা আগধন হিচাপে লয়। মই বহুবাৰ মোৰ পৰা পাব লগা টকা বিচাৰি যোৱাত পদকীয়ে মোক পৰ্যায়ক্ৰমে 1,25,000 টকা পৰিশোধ কৰে, যদিও বাকী 4,50,000 টকা আজিলৈকে পৰিশোধ নকৰি মোৰ সমুদায় টকা আত্মসাৎ কৰে। বৰ্তমান পাবলগীয়া টকা বিচাৰি গ'লে পদকীয়া আৰু তেওঁৰ পত্নীয়ে আৰতিৰ পাতৰে নিজৰ ঘৰতে মোক নানা অশ্লীল গালি গালাজ পাৰি নানা ভাবুকি দিয়ে। They have said that they have paid 5,75,000 in FIR, but originally they have paid only 1,50,000. One thing. Second, Lordship, case was registered in the sections 319, subsection 2, 316, subsection 1. This is a definition of breach of trust. 316, subsection 1. And 296 is there's a Options Act. It must be in the public place, Lordship. These two sections are not applicable. And regarding 319 personations, Lordship, no question of seating of personation is applied to. The purely civilian nature. I have paid. I have that owner of the land, and they had reached the agreement. They had failed to give this amount within a specific period, and I have sold that amount, sold their land to the other persons, and I have paid their 1,25,000 to them.
They paid 1,50,000.
1,50,000.
You paid 125.
125 to them.
Well,
Because
Lordship, in this case, Lordship,
there's 25,000 retained because there is some expenses. Lordship. I'm ready for this agreement and for the sale permission also.
yes. Yes, continue.
Yes, Lordship. Thereafter, Lordship, only thing is that, Lordship, no criminal intimation is there, Lordship. What is the necessary for the trial, for the criminal proceeding, Lordship? I'm depending on the one case, Lordship, Bhajanlal and others, Lordship. Is a state of Haryana and others. Lordship is very much aware of that. Para 102, that is 378, Lordship, page. Lordship.
Yes, 1, 2, 3, 4.
Yes, 1, 2, 3, 4. And as a 5 is very important, 5 and 6 are. What the allegation is made in the FIR or the complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused. 1. Where there is an express legal bar encrypted in any of the provision of code or concerned act under which a criminal proceeding instituted to the institution.
This is
or
not your case. Bhajanlal is not the decision to be cited in your case. There are other
Lordship,
decisions
there
regarding.
is a guidance for where honorable court can.
Your case is that it is a civil nature.
Yes, civil nature also.
It is
That's why I'm saying yourself. I'm submitting yourself.
Lordship, in this case, Lordship, I may be appearing on behalf of respondent number 2. in this
Have you
case.
completed?
Yes, Lordship, you can go. But
Lordship, actual fact is that, when the agreement was made, Lordship, the petitioner, the respondent number 2 has paid an advance amount of 1,50,000 with a precondition that the 50% amount should be paid at the time of execution of the sale deed. Lordship, what I mean in this case, moreover, in extent to that, Lordship, she have paid another 2,33,000 rupees. My learned friend fully suppressed the material facts. I've annexed all the bank transaction, Lordship. Kindly peruse the page number 38. It's a bank document of the respondent number 2, Lordship. On 17/9/2019.
Yes, 38.
Yes, 38. And relevant portions, Lordship, I have typed the portion at page number 37, Lordship. Kindly peruse the page number 37, Lordship.
Yes.
The extra portion of the bank statement of the respondent number 2, whereas she had paid rupees 63,000 on 17/9/2019, on 1/11/2019, 80,000, Lordship. Now, come to the page number, Lordship, 42, Lordship. Lordship, the amount 80,000 and 60,000 has been paid through the bank of HDFC Bank, Beltona branch, and subsequently again paid through Union Bank of India, Lordship, in page number 42. On the same date, 5/9/2023, rupees 50,000 and 40,000, Lordship. Yes, if it has been counting, Lordship, the total sum of rupees 2,33,000 rupees has been paid, apart from the 1,50,000, Lordship. And whenever she went to the house of the petitioner, Lordship, she was physically molested, Lordship, in this case. So that's why under such compelling situation, she have filed a FIR, Lordship.
Lordship. Your petition is for the FIR is for the whether recovery of the money or for the punishment, Lordship. If recovery of the money, there is a civil.
Although my learned friends tried to establish that as a civil nature, no, Lordship. In this particular, Lordship, the fraudulency nature is fully proved, and he himself submitted false information before this court that he have returned 1,25,000, but in respect of that, no bank documents has been submitted, Lordship.
FIR itself says, Lordship, what he has submitted, Lordship. FIR itself says that I have returned 1,25,000.
And expenditure cost of rupees 25,000, how can he determine that the expenditure cost is rupees 25,000, Lordship? And if I trying to, Lordship, project the dispute as a simple civil dispute, Lordship, which is fully in misconceived. Because apart from 1,50,000, Lordship, she has again paid 2,33,000 through bank, another cash amount of rupees, Lordship. 3,42,000 by cash.
Where is that cash payment?
There is no documents of case payment, Lordship.
There is no document for cash, Lordship, but apart from 1,50,000, another 2,30,000 has been paid through a bank transaction, Lordship.
How much?
2,33,000
2,33,000 through bank.
through bank, Lordship. Apart from the agreement value.
No, Lordship, we say included amount, Lordship. These things
Because
is-
when the agreement was executed on that particular day, Lordship, she has paid 1,50,000 to the petitioner, Lordship.
All right, date of agreement. That is,
Lordship, the
20.
agreement date was not stated in the
2020,
agreement,
Lordship.
Lordship. Date of agreement was not stated.
The 2020, Lordship.
Lordship, in the
there is no date in the agreement.
in nowhere the date is reflected in the said agreement, Lordship.
But agreement is not denied.
Yes, Lordship, agreement was executed, but when the agreement was executed, that was not stated in the agreement, Lordship.
Case was registered under these sections, Lordship. 319, 316, subsection 1. This is the definition of bishop trust. And 296, Lordship. Options Act. It should be in public place. And 319, subsection 2. This is a seat of personations, Lordship. How could be applicable, Lordship?
Lordship, it is settled law that Lordship examining truthfulness or otherwise the allegation can be examined in proceeding for crossing Lordship as the same as be matters to be investigated if necessary. Lordship.
When did you, agreement is of say year 2020?
Yes, Lordship, 2020 Lordship.
But in the agreement, Lordship, no date has been mentioned.
So when did you pay your 2,33,000?
Lordship, on 17/9/19, 1/11/19, and Lordship, 5/9/2023.
5/9?
2023, Lordship.
What is the amount on that date?
2020, the other two amount has been sent, 50,000 and 40,000, Lordship, through Union Bank of India, Adabari branch.
On 11/9?
Lordship,
On 11/9/19?
1/11/19, Lordship, rupees 80,000 through HDFC, Beltola branch.
That is page?
Lordship,
Which page is that you have annexed?
Lordship. Page it at Lordship, page number 41.
That is 41 and this 5/9/23 is page?
Five nine 23 is at page Lordship, page number 46.
And 17/9/19, what is the amount?
79/19 amount was 63,000, Lordship.
That is page?
Lordship, page number 39.
So 2,33,000.
Yes, Lordship.
Their amount itself is very Lordship. They said it 5,75,000 they had paid.
Hmm?
They said that they had paid 5,75,000 to me in the affair. And I have
And
returned
yes, amount of
150,000.
rupees 3,42,000 has been paid through cash, Lordship. 3,42,000 has been paid through cash.
There is no such documents, Lordship.
All right. So these first two payments are before the agreement. That is covered in the 1.5 lakhs. The agreement is of 2020.
Lordship, in the particular agreement, there is no debt mentioned, Lordship. Can
It
you
is
peruse
not
the agreement,
mentioned, then
Lordship?
how do you
Page
make
number-
out a case?
Out of imagination, he has just put up the year.
No,
Okay, kindly page the page number 17, Lordship, of the,
You have signed the agreement, have you not?
yes, Lordship, but the date is not mentioned in the particular agreement, Lordship.
Yes, so whose benefit that will go to?
Whether the agreement was executed here in the 2019 or 2023. I don't know, Lordship.
but he said that their first amount is paid on 17/09/2019, 63,000.
But if the, if it is assuming, Lordship, the agreement was made in the year 2020, in subsequent to that, in the year 2023, the respondent number two had paid again 90,000 to her.
Yes, so in your affidavit in opposition, you have not denied that the agreement was executed in the year 2020. Rather, it seems you admitted. So that has to be taken as the year 2020. So after that, you paid an amount of 90,000.
Yes, Lordship.
But that amount is not mentioned in the FIR, Lordship.
He says total amount.
Total amount is given. That's why, Lordship,
That is his case, that he has paid this total amount. Out of that, this much is through bank and this much is through cash. Cash part there may not be evidence, but the bank part, the evidence is there.
regarding case amount, Lordship, there is no any such documents that they have given that amount.
You admit to have received 150 and returned 125. But what about the 90,000 that he paid you?
That's why I'm saying that this is a pure in civil in nature. If they have time, can
Lordship,
file that specific relief act or in money should.
If at this
then
instance,
this
Lordship,
question needs to be
the
arised
instant
there.
petition has been
Because
passed, Lordship.
there is a
The
provision for
respondent will suffer
recovery.
irreparable loss and injury, Lordship. Let the matter be established in the dealing procedure of trial, Lordship.
That is not a
FIR
question.
is
If
for
we
the
find it is
recovery
of a
or-
civil nature, then why will we keep this petition pending?
My submission is that, Lordship, is a for the recovery or for the harassment of the this petitioner, Lordship. If recovery, then there is a proper provision, Lordship. Because in criminal case, no recovery will be going out. And there is no source of intention, Lordship. They have failed to their conditions, terms and conditions in the
Lordship, when the
agreement.
respondent
They
number two went to the
they
house
not
of the
complying their-
petitioner, Lordship, she was physically assaulted, Lordship.
That is totally false, Lordship.
No,
They
no,
have not
he
complying
himself,
the
he
agreement,
himself,
all the
he
operating
herself
conditions, Lordship.
stated in her FIR that বৰ্তমান পাব লগা টকা বিচাৰি গলে পদকীয় আৰু তেওঁৰ পত্নী শ্ৰী আৰতী পাটৰে নিজৰ ঘৰত মোক নানা গালি গালাজ পাৰি নানা ভাবুকি দিয়ে. That was the criminal liability, Lordship. If my learned friend tried to establish this is a monetary transaction and same has been treated as a civil nature dispute, but that is not true, Lordship.
Even Lordship 296 is not applicable here. Because it notice in the public place.
Let the matter may proceed for trial, Lordship. During the course of the trial, that should be established, Lordship.
All right.
Therefore, I beg to prepare your Lordship to dismiss this petition, Lordship.
All right.
My humble submission is that if FIR is for the recovery,
Lordship,
then there is a
The
specific.
petitioner has filed
Please,
this petition
let
fully
me
suppress the material facts, Lordship.
No, I am not submitting.
Because
Suppress
this
it.
petition has been filed in the year 2025, but the amount has been received in the year 2023 also, Lordship.
They have not
Fully
mentioned that
suppress the
things,
material
Lordship.
facts, Lordship.
They have not mentioned that things, Lordship, in the FIR also. Only thing is for the recovery, there is a specific provision, Lordship.
That
There
is a
is a for-
separate issue. See, you file.
Yes, yes, we have heard you. You have no further points to make, I think. Yes. Yeah.
Deeply obliged, Lordship.
May I please, your lordship?
Yes.
My lord, this criminal petition, my lord, is preferred to, we have challenged the FIR for quashing of the same, my lord. My lord may be pleased to find the FIR is at, my lord, page 11, annexure A to my petition, my lord. May I read, my lord, at annexure A, my lord,
Page.
page 11, page 11. 31. Lord, this is an Lord addressed to the officer in charge of the Lahori Ghat police station by Lord, by the one of the police officer in charge of the same police station against some of the accused, Lord, wherein my name is not there, Lord. I have the honor to state that having learned from a reliable confidential source that 25 bulls were illegally carried by a truck bearing registration number so and so, and that the cattle bulls were unloaded at the embankment on river Brahmaputra at Tangaguri. I, along with the staff, caught the empty vehicle with the driver in front of the Lahori Ghat police station, while he, the driver, was driving the empty truck towards the Lahori Ghat market around 8:30 a.m. on 17/4/2022. The accused was taken to the bank of River Brahmaputra at Tangaguri, and having found the bulls there, the same were seized. A case was registered in this regard, and the SI Dhiren Saika Sonwal was tasked with the investigation, and he proceeded with the investigation of the case. But as per the allegation in the news published, broadcasted by the Assam Live 24 channel, 3 more bulls in addition to the 25 bulls were kept concealed in the chor on the bank of River Brahmaputra, and having learned about the 3 additional bulls, the accused persons conspired with a person of the chor and sold one of the 3 bulls to that person in exchange of rupees 20,000 and concealed the matter. Later on, these 3 bulls were recovered after inquiry. I therefore earnestly pray to your good self to investigate the matter and take necessary action in this regard, and oblige.
You have some submission.
Lordship, the CD is here, Lordship, but unfortunately, Lordship, the CD has not been updated since last year, Lordship, 15/11. I have talked with the IO also, Lordship, so if get the CD updated, Lordship, which will be necessary, Lordship.
Charge sheet may have been filed by now.
No, my lord.
CD is here, Lordship. It has not been updated since last year, Lordship. 15/11/25. IO has, I have also spoken to the IO, Lordship. It will be updated, Lordship.
My lord,
Then the matter may be decided.
my lord, my respected friend, submission is fair, my lord, as the case diary is here, my lord. My lord, our case is that I am not a named accused in the FIR, my lord. Now the involvement which has been arrived, perhaps maybe from the statement made by the co-accused. Now, my lord, the case is languishing from since, my lord, 2022. And, my lord, there is no investigation, no, it had not been proceeded also, my lord. So therefore, on the delay ground, as I am a constable of the same police station, my lord, I was working. So therefore, my lord, my service due to this case, my lord, my promotion and other aspects is also, my lord, in abeyance, my lord, cannot proceed further. So on those grounds, my lord, we are now before my lordships, my lord, with the prayer that the delay and, my lord, the material which has been collected also does not disclose any direct involvement or indirect involvement of the accused with the case also, my lord. I was also arrested, I was also arrested, my lord, and later on enlarged on bail also, my lord. My bail
It is
order,
not a case where the FIR does not disclose an offense.
my lord.
It is the offense has been disclosed, you are not named in the FIR, but investigation may reveal your involvement.
Exactly.
So, so on what basis do we quash the FIR?
My lord, may examine the case diary, my lord, what the materials are there, my lord, and the, my lord, the police cannot keep the case.
We are
my
not,
lord,
we are
this-
not,
this-
we, in this exercise of this jurisdiction, we are not, we appreciate the material and then pass order. That is for the time of consideration of charge.
My lord,
It is a case of absolutely nothing, no material, no, that's a different issue, but can't appreciate evidence and then
No, my lord,
pass orders here.
my lord, I am not praying that the, my lord, the trial should be conducted at this stage. Prima facie, at least some material should be there against me, my lord. Now,
Yes.
what the material is there, my lord, the police, no doubt, my lord, the police has arrested me also. Now, my lord, the material what discloses in the case diary against the petitioner, my lord, can appreciate that also, my lord, and we can only pray before my lordships, my lord, that it is the,
That's
my
what
lord,
the
the,
submission is.
my lord.
The CD has been not been updated.
My
Also. Let it be updated with the materials that has been collected.
That
And
is
therefore,
what-
Lordship, decide.
My lord. Huh?
Third learned counsel for the petitioner, it is submitted by learned additional PP that the CD has not been updated since
11, November 25.
2025. That the updated CD will be necessary. Is the updated matter again on
2nd of September, Lordship.
My lord. Obliged, my lord.
This is a notice was issued and maintained and it has appeared for the respondent, but the PCR was not called for in this case. Call for your.
for petitioner. So and so appears for respondent number 2.
1 year.
Sole respondent. All for the scan copy of the PCR. Again on.
Obliged.
My lord, yes. Cases, my lord, we have challenged the proceeding in item 22, my lord. We have challenged the proceeding under 125, 144 BNS, yes, claiming maintenance by wife. And the other case, we have challenged the domestic violence proceeding, my lord. Our sole ground is that, my lord, the marriage is not there. He has falsely stated that we are married. That is the ground in both the cases. You know, their own statement at different stages would prove, Your Honor. Your Honor, may kindly turn to page number 60 of my petition. You know, this is an application. It starts at page 59. Filed before the learned magistrate under Domestic Violence Act. Kindly turn to page number 60, my lord. Paragraph 2. That the applicant begs to state that her marriage with Suraj Chetri was solemnized on January 2015, which was registered in 3/11/2015.
Yes.
This is our statement that it was registered on such and such date, but no document showing the registration of marriage has been furnished by her. And further she says, and after marriage, she started her conjugal life at her matrimonial home at Jyotinagar, house number so-and-so, Sanmari, Gauhati. Thereafter, Lordship may kindly turn to page number. This is the statement before the domestic violence proceeding. We have challenged this proceeding. We have come for quashing in the other case. Lordship may kindly turn to page number 74 now. This starts at page 73. This is an affidavit in opposition filed by the opposite party before this honorable court in that quashing petition. At page 75, my lord. Page 74. Para number 4. That the statement made in para 3 of the criminal petition that the opposite party denied the same, answering opposite party. This opposite party is the wife, my lord. Answering opposite party state that the petitioner love affair with opposite party and thereafter their marriage was solemnized as per Hindu rites and rituals on January 15 at Krishna Mandir, Narangi, Gauhati in presence of opposite party, in presence of our parents and well-wishers. Thereafter petitioner and opposite party living together as husband and wife, so and so, so and so. Here she says before the Honorable Gauhati High Court filing
This is the affidavit of the wife.
yes, that it was a registered marriage somewhere in a mandir. Now, Lordship will kindly turn again to page number 88. This is the petition under 144 of BNSS claiming maintenance. Starts at page 85. This is what I have challenged in this proceeding. Lordship may kindly turn to page number 88. Para 6. That the petitioner first party is the legally wedded wife of the respondent opposite party and the marriage was solemnized at Jonai in the district of Dhemaji. After solemnized in the district of Dhemaji, Assam, according to Hindu rites and rituals. Now we'll have 3 different places and inconsistent stand at each and every stage. And we have filed our written statement before the learned magistrate in DV proceeding. There also we have categorically said there was no marriage, and in fact this petitioner was not attained the marriageable age at that point of time when it was alleged to have committed murder. They have some relation at the time of they were students. They were in PG somewhere here. So you may see the denial at page. We'll find the denial at page 53. (52) is the written statement we filed before the domestic violence proceeding. The next 3. Kindly turn to page number 53.
Yes.
Para 5. With regard to the statement made in point number 2, the details of the respondent and the respondents being the begs to state that the statement made therein are partially correct and admitted, but both the respondent strictly denies that the respondent number 1 is the husband of the agreed person. In domestic violence, my mother was also made a party. So we have filed a combined written statement. We denied everything, my lord. There was no relation as such. And she has also claimed, my lord, that pregnancy of all, and that is also contradicting her own statement. But whatever may be, my lord, if marriage is not established, the procedure under domestic violence will not, and the maintenance claimed by wife under 144 of BNSS will also not be there. So we are basically challenging the marriage, my lord. On that count, I am on quashing of Buddha proceeding.
What is the finding of the court?
My lord, which court, my lord?
You were not challenging a particular order,
No,
the entire
proceeding only.
proceeding. Yes.
My friend is heavily relying on the act, which is case under the Domestic Violence Act, and he has referred certain documents. There is just different dates and different places mentioned. But if when the domestic violence case under the Domestic Violence Act is filed, before taking cognizance, normally court invite or asks the report from the protection officer, which is called domestic incident report. Domestic incident report is prepared after preliminary inquiry and after getting information, and if the protection officer is satisfied that there was a domestic relationship between the complainant and the accused at any point of time, then he prepared a report and sent it to the court, and on the basis of that report, the court took cognizance. But in this case, there may be some variation which my friend has referred, but throughout his submission and the petition,
This criminal petition number 35 is with regard to the 125 proceeding.
Yes, but he is relying on the cases which is pending before the JMFC first class, which is about the Domestic Violence Act, and more particularly, Lordship, the case has become this. The case is decided already. Expiry decided.
Which
In fact,
case?
this is the case which is instituted under the Domestic Violence Act. They remained absent.
All right, that is the next item.
Next, take together. He is here because he is referring page number 44, page number 60. These are the part.
No, he can refer to it. He is challenging the 125 proceedings. He can show from whatever source he can that no marriage exists.
Yes.
That is his submission.
No, that is true. So I will confine my submission within the 125 proceedings. Lordship, this marriage, one thing is that they are telling that I am not legally married wife. No marriage was solemnized. They have referred certain statement which is made out in the different proceedings which is pending in the different court. So I am claiming they are denying. So how I will prove that I am the legally married wife? Because I'll have to adduce evidences. I'll have to examine certain witnesses. These are the process, because it is admitted fact that the marriage was not registered before the sub-registered office. So it was performed as per the Hindu rites and rituals. So as to prove that, Lordship, I need to adduce evidence. This court, I think, they have challenged, rather they contest the case before the learned court of the principal judge of the family court. They will get an adequate opportunity to adduce evidence to deny my claim. So in criminal proceedings, proceedings initiated under the criminal petition, so this kind of claim is a disputed. They are claiming, I am denying. I am claiming, they are denying. How this court will find out a appropriate solution, Lordship? Only the way is adducing evidence, examining the witnesses. As Lordship may come down on the page number 3. Then certain information is given which is also not correct and not authentic. Page number 3 I am referring. Page number 3 of
Page number 3.
Page number 3, paragraph number 3. May I have a permission to read the small paragraph, Lordship? That the respondent was trying to come in close contact with the petitioner, offered him a proposal of marriage, which was however However, outrightly denied by the petitioner. After the petitioner denied the proposal of the respondent for marriage, she, along with the mother, tried various means to convince the petitioner, but he was quite clear on his stand not to marry her. As a result of that, the respondent instituted FIRs against the petitioner on the false concocted stories. Pursuant to the FIR lodged by the respondent, the petitioner was subjected to face criminal trial in GR case 2162 of 2016, registered under section 417-294-506 of IPC. The GR case number 4091-2016 under section 341-32 and 506 IPC. In GR case number 2162 of 2016, the petitioner was acquitted after trial on 22/8/2007, and GR case number so and so was disposed on so and so, and as a uncontested for the withdrawal of the prosecution under section 321, the petitioner leaves the court to produce the case record pertaining to the GR case. Let's see, another GR case is there. Interestingly, they have hidden the fact. The GR case number 4586 of 2016. And it is registered under section 498A. And trial is going on. So this entire petition itself not maintainable because they have suppressed the material fact. If necessary, Lordship, if Lordship may fix a date, I will produce the relevant document also. 498A. What does it mean? It is diary. So if there is no domestic relationship, if there is no wife and husband relationship, how the police come to the conclusion and file the charge sheet? That is why I am, Lordship, submitting that they will have an opportunity to contest the case in the court of the principal judge of family court. Because, and secondly, Lordship,
Just a moment, what was suppressed according to you?
Because
You're reading from this page 3 is his petition, is it not?
his petition, yes.
Yes. So what is suppressed here?
Surprise, they have stated certain facts that there was no domestic relationship, there was nothing was there, and cases was filed, and which was
That is his whole case. What is the question of suppression?
certain information they have not given. That is why I am trying to place before the court that another case, GR case number 4586 of 2016, which is registered under section 498A. It is still, trial is going on. So if they give the information that has to be complete, because some informations may come in their
What is
favor.
that, GR?
GR 4586 of 2016.
Before?
Lordship,
Where is it pending?
it is pending in the CJM Court of Kamrup Metro. And it is fixed on 14th
14th of September.
this month. Basically, it was filed on because the notice was not served. Accordingly, the complainant has filed an application before the court, and accordingly it is fixed on 14th of this month, that is day after tomorrow.
So I'll take instruction on this, my lord.
And Lordship, and this paragraph number 4. Again, the respondent has also instituted the case under the Domestic Violence Act 2005, being Miss Case number 106/2016, against the petitioner and his mother, which is pending disposal in the Court of Landed Subdivisional Judicial Magistrate, Sadar 1, Kamrup Metro. Just I had submitted that they are heavily relying on those facts of the case, and this is they are trying to establish that there is no domestic relationship. But Lordship, law is very candid and clear. When the court of the judicial magistrate take cognizance of a case instituted under the DB Act, first they invite the DIR, Domestic Incident Report, and which is prepared after investigation by the protection officer. So if there is no domestic relationship, how can the domestic incident report be prepared? And if they are aggrieved, then they can challenge. They have contested the case without challenging the DIR report. The DIR report confirmed, yes, there was a domestic relationship. And my friend is submitting before your lordship that no marriage was solemnized. Without marriage, how can there be a domestic relationship? They are silent about it. So it is, Lordship, this, in fact, my submission is this petition itself unmaintainable. In paragraph number 5, Lordship, the petitioner states that the respondent narrated false, vague and concocted story before the protection officer, incriminating the petitioners so as to bring them within the realm of Domestic Violence Act 2005. The respondent did not mention the date and place of the marriage and also how the marriage took place, but conveniently placed some medical documents to attract the attention and emotion of the protection officer. If they are not satisfied with the report prepared by the protection officer, it has to be challenged. And this code is not the forum. Lordship is well aware that that under section 23 of the
How is
DBI,
the report challenged?
the DIR report can be challenged, Lordship, if they are not satisfied. If they believe that
I will challenge the entire proceeding in domestic.
entire
violence
proceedings and entire proceeding is not the forum, Lordship, it can be challenged that before the district judge is the appellate authority. Jumping the district judge court, they have
It is not
directed.
an order of the court. It's a report. How can that be challenged before the district judge? There what provision?
Because cognizance is taken on that report, na?
Yes, order of cognizance can be challenged.
Cognizance can be.
That is a different thing. How
They
can
are
the report
challenging
be
the
challenged?
proceedings and cognizance where to be challenged, Lordship.
No,
The
once they have,
district judge-
once they have challenged the entire proceeding, what is the meaning of separately taking,
Lordship, yes,
challenging
yes,
the
yes.
cognizance?
My submission is that today I am not carrying the Domestic Violence Act. If anybody is aggrieved by any order passed by the JMFC while trying the DB Act, a case under the DB Act, there is a appellate forum.
Section 29.
Section 29, yes. Sorry, I was
Yes.
wrong. So by passing the section 29, they filed criminal petition here. So all these things, Lordship, these are disputed fact. It is not a fact of the law that which can be decided under the section 521 under the criminal
No, that
petition.
section 29, that will be applicable to the other case.
And
This is a
here,
125 proceeding, separate one before the family court.
Yes.
The DV Act, that DIR relates to the DV Act case.
they are relying while I'm just reading out the
I have
petition
enclosed
under
those
section-
document as annexure I have marked.
No, as far as this second case is concerned, he says it has already been
It is-
decided.
Kindly fix it on
So
another.
your
that-
petition is already in fructus as far as the second
I
case
have-
is
I
concerned.
have to take instruction on that.
Because on the 1st of September is fixed for the final order, ex parte hearing is concluded. They
First of-
remain, 1st of, I'll give the date, 1st of, probably
Document,
7.
I'll fix it another day. I will take instruction on both this 498A, I am not aware, I am not instructed on this also. Learned friend says
That
it
may
is
not
fixed.
be so relevant, but
That cannot be, yes, but whatever statement made on affidavit by the respondent in different proceedings of court, even before this Honorable Gauhati High Court also, she gave inconsistent statement.
Then there, this is the
And he has
issue
no
is
answer
that-
to that.
No, this is the issue is that, in fact, I'll go through the, I'm appearing for the first time also. And in fact, there may be some typological error or variation or something else.
Repeatedly.
But one thing, please.
Sorry.
But issue is that whether marriage has been solemnized or not, whether there was a domestic relationship or not, how this thing can be proved? It has to be proved before the trial court by adducing evidences and examining witnesses. It is not, it is a question of fact, Lordship, not the question of law.
all right, when do you get your instruction? Because we have already spent considerable time
Yes,
in
Mr.
this, we don't want this to be for nothing. We'll dispose of this.
Next week, my lord. Detail was it?
Next week will not be available. You get it by Friday,
Friday, my lord.
Friday of date?
this Friday.
No, Lordship, in 14th, at 2 PM, Lordship.
What instruction is required otherwise regarding this criminal case?
Yes, regarding the criminal case, that is also as per my learned friend submission, my lord, that is on fixed on or 14th. I don't know, my lord, I have not. 14th of August is.
No, that I have submitted, it is filed and because the notice was served and he escaped from his native place, then the report came that he is not available. Accordingly, it is filed on and the complainant filed an application annexing the relevant document confirming his address. Accordingly, she will move on the 14th.
That information we can get in a minute. It is from Kamrup.
Then let it be at
That
2
is-
today itself, my lord.
Not too, Lordship. I have some other engagement, any other date.
All right, Friday.
All right.
At 2 p.m. Lordship.
Hard learned counsel for both the parties. The matter are again on Friday to enable obtain instructions regarding pendency of their case against the petitioner. Friday.
All right.
I have a small request, Lordship. Can it be taken at 2 p.m. on Friday, Lordship?
All right, two.
Fixing at 2 p.m.
Obliged, Lordship.
Please, Your Lordship. It's an application against the order of rejection of Jimma, my lord. My learned friend is appearing for the excise department, my lord. What happened, my lord?
Yes, any instruction?
My lord, I've been informed that an application to initiate a confiscation proceeding before the collector as well as magistrate, that has been done. Only, my lord, I have not received a copy, my lord. So I am seeking today's accommodation, so I can, my lord, receive a copy of the.
What I am submitting, my lord, as per section 74, my lord, they cannot confiscate, my lord. Have a look, my lord, section 74 of the Assam Excise Act, my lord. There is a-
Yes, you will have to challenge the confiscation proceeding.
In that, my lord, they did not start any.
All right, let him
confiscation,
get
my
the
lord.
instruction.
1 year already gone, my lord.
Hard learned counsel for the petitioner, learned counsel appearing for excise department submits that according to his information, he had an application for initiating confiscation proceedings has been filed before the district commissioner and seeks further time to submit proper instructions, obtain proper instructions, documents in this regard. Matter again on when?
After a week, my lord.
That may be fixed, my lord.
26.
Obliged.
May I be please, my lord? A CR case was instituted, my lord. That is upon that against the petitioners. One legal issue is involved in this application, my lord. There's the London magistrate straightway taken cognizance and issue a notice. Subject this provision of 223, the court has not applied, my lord. That's the issue. And is settled by the coordinate bench of this honorable court, my lord, that before issuance of notice, you have to examine the witnesses, complainant and witnesses. And this is judgment delivered.
Where is the impugn order?
Impugn order? Page 17. Page notes. No, 34. 35, my friend. 35. Last page.
This is only notice to the accused as per the new
Yeah,
provisions
so
of
now
GNSS.
the question is, my lord, that before issuance of notice, you have to examine the complainant and if any witnesses therein. So before exercising that by the learned trial court, straight to issue the notice. And then I will place the judgment recently, my lord, of the coordinate bench of this court that has been clarified. But you kindly have a look at the provision itself. The prefix says the examination of complainant of the provision 223. 223 starts with examination of complainant, the prefix said. Now, provision says that no cognizance shall be taken unless there is a notice.
Yes.
Lordship, can you have a look at para 17, 19, 22, and 23? Can you have a look first, para 17? May I read?
Yes.
Para 17, in view of the aforesaid discussion, this court is of the view, considered view that the issuance of notice to the accused prior to examination of the complainant and the witnesses, if any, is not for what is mandated under section 223(1) of BNSS 23. Rather, what is mandated is notice to be issued to the accused only after examination of the complainant and the present witnesses, if any. However, this is only when the magistrate does not want to exercise power under section 226 of the BNSS.
The sequence is first examination,
Yes,
then
then
notice, then cognizance.
Then after hearing, if hearing the complainant does not disclose anything, then dismissed or otherwise cognizance.
Lapse is there. Procedural lapse is there.
So you admit.
Yes, you
Remanded with the matter.
remand back here. Impugn order is maybe set aside and remanded. I have also gone through this.
Yes.
What happened, my lord, this judgment not circulated throughout the state. So still there is some mistake committed by the learned magistrate, my lord.
Because this confusion is caused because the word while taking cognizance.
That's the.
That line is there.
Yes. Now
So
other
that
high
creates the confusion
Yes,
that while I am recording, am I taking cognizance?
Yes, yes. When
For
at the
taking
time of
cogn-
when.
that is the
Correct.
problem.
Correct. That the confusion. Now it is rest, my lord. Other high court also says, and considering the other high court's judgment, this high court, my lord.
Otherwise, it becomes meaningless. Once cognizance is taken, then he becomes an accused.
Yes, absolutely.
Then you cannot
What
issue,
the
you have to
prior-
issue summons.
Is it pre-cognizance stays hearing? Pre-cognizance stays hearing. Meaning thereby the no frivolous complaint to be carried on, my lord. That's the intention of the legislature.
Well, it will pass the order.
Right.
We have to get
Right.
on with the bail hearings.
Great.
Lordship, we are filing the affidavit in the course of the day. Lordship, make
Third, learned counsel for the petitioner, learned counsel for the respondent number 2 submits that an affidavit in opposition will be filed during the course of the day. Hence, list the matter along with the said affidavit.
So the interim may be extended, my lord.
Team order passed earlier to continue.
obliged.
Item number. take the instruction if charge sheet has been filed or not. Charge sheet has not been filed, Lordship. So date may be given for
Not filed.
not filed.
Lord, I was praying on that ground, Lordship. First child is going to take back on 17, Lordship.
NDPS
There
case,
is
Lordship.
50 days in custody, 21B is there, Lordship.
27A is also
And
there.
on merit, Lordship, he is the driver of the vehicle. Another person was arrested, co-accused person. The recovery was made from the beneath of the co-driver seat, Lordship. I am not on merit, I am just praying because of that condition. There is much expectation, excitements are there, Lordship, may kindly consider that aspect, Lordship. On 17, Lordship, it is given, it may come forward or may go back, Lordship, that your Lordship knows well, Lordship. Lordship, kindly consider that aspect, 50 days in custody.
You are the person from whom the recovery has been made.
Yes.
No, Lordship, Lordship may kindly see page 17. Forwarding report, it is stated. Recovered from beneath the front passenger seat of the vehicle. Passenger seat. And there was another co-accused person. He is also arrested. Page 17 in the forwarding report, it is mentioned. Lordship.
All those matters cannot be taken into consideration now. If since 27A is there, 37 is attracted, and without considering the CD, we cannot say that you are not guilty of the offense, which finding is necessary to release you on bail.
Lordship, 21B is also there, Lordship. May kindly, I am not
21B
on
is
merit,
there,
kindly
but
consider
27A
this.
is also there.
That is true, Lordship. I am.
And if it is true, then
I-
there is no
I-
further
I
submission
am
to be
praying
made.
only on this ground, Lordship.
That ground is not permissible. Section 37 does not make any exception.
And it is clearly written, page 17, Lordship, may kindly see that the recovery was made from the beneath of the front seat. And
So-
there is one co-accused person, he is also arrested, Lordship.
So-
And this is a commercial vehicle that
All
was.
the CD will reveal whether he
that
is
was
your
hired by the-
cousin, whether he is your friend.
And Lordship may kindly take it up on Friday, Lordship. It is from Mukalma only. On
Before, Lordship,
Lordship,
difficult, Lordship,
on
Friday.
Friday, Lordship.
Meaningless.
Friday, Lordship, my learned friend has also
24.
communicated. He can produce on that day,
I
Lordship.
cannot produce, Lord. Good, Lord.
He has also made communication, Lordship.
Right, Monday.
Oblige, Lordship.
Copy one. Extra copy দিয়া হৈছে। My lord, my learned friend is saying that he has not received the copy of the petition. My lord. We have already furnished, my lord, and it had been received, but my lord, we will furnish another one, my lord. There is no issue. My lord, prayer for quashing of the entire proceeding, my lord. Therefore, my lord, their stand is required.
Learn it. For the petitioner, learn it. And for respondent number is yet to receive a copy of the petition. Can be served upon him. Record is received or not called for. Here. Here is here.
My lord, my lord.
This is the matter again on.
First week of September, my lord.
Correct. Interim order passed earlier to continue.
Lord, there is an interim protection that may kindly be continued.
Yes, yes.
My lord. Obliged.
Happy the lordship. Lordship, enthroned judgment is on page 12, my lordship. Round, my lordship, on para 2, my lordship. Maintenance to the child, my lordship, the petitioner has denies the parentage of the child, my lordship. Exemption under 112, my lordship, will not be drawn.
Respondent number 2 is presented by the legal aid council lordship. Bordeaux. It inform us to time being lordship. She'll be
What is this case about?
My lordship, it's a maintenance case, my lordship.
Maintenance.
Maintenance. Our case is that, my lordship, she could not establish any marriage, my lordship. And moreover, she herself has deposed that she was already 2 months conceiving, my lordship, when.
All right, let her come.
I did it.
Praying for timing, Mr. Chaudhary is in.
Item 31.
This case TCR has been received.
That's in the lordship, right? Order dated 28/7/26. Was granted default bail lordship. So it has been.
Then
My lord, I don't have anything to say. Just I want to just point it out to my lord is that the charge sheet has been filed on 25, long before the statutory period, expiring of the statutory period, and the petitioner then I don't know how they have manipulated anyhow by misguiding the court that they have taken the bill, my lord. So this much I want to submit.
Order dated 28/7 lordship. There is no charge sheet in the records. No charge sheet in the records. I have seen.
do you have any charge sheet number?
That sheet number, my lord, there was earlier in this order, my lord, maybe here, maybe inside the court's
Charge sheet
order.
number lordship is 126.
Charge sheet number.
Yes.
That is subsequent. Dated.
Dated lordship 20 of May.
Where is the order of bail?
Bail order, lordship will find it at 28/7/26. Order dated.
(28/7)
Yes.
26.
Yes.
No, sir, charge sheet is here. Where did you get it? Charge sheet is here. No,
Overlooked, Lordship, but they,
no, it is not here.
it's not there, Lordship.
My lord,
We had the instruction, Lordship, that charge sheet has been filed.
On?
We have the instruction
On
2005.
05.
05.
Yes,
And that was much before.
yes. So, but the charge sheet copy, Lordship, the records, Lordship. That order also, Lordship, reflect that nothing was before the that day, Lordship.
Anyway, this has become infectious
Yes, this has
since he has been released. Learned counsel for the petitioner and learned additional PP. The TCR has been received. Wherefrom it appears that by order dated 28/07/26, the learned additional CJM has directed the release of the petitioner on default bail since the statutory period of detention had expired on 24/0. But this was a 60-day offense, obviously.
90 days.
90 days.
Yes.
As the statutory period of detention of 90 days had expired, the accused was arrested on 24/3/2026. Petition has become infructuous. However, submitted by learned additional PP that as per instructions received, the charge sheet was filed on 20.05.26, which was much prior to the expiry of the statutory period of detention. The learned Chief Judicial Magistrate Kamrup Metro conduct an inquiry into the matter, take appropriate action as per law. Communicate a copy of this order to the learned CJM Kamrup Metro. The petition stands dismissed as in fact.
Lordship, that this may be kept on record, Lordship.
Receipt number 126. Or 126 of 2005. Communication of the IO 12/6/26 kept on record.
Lordship, regarding instruction of service, Lordship. One instruction. Accepted matter, Lordship.
Seated, he is in jail for about 1 year. 351 days today.
There is a office note also, Lordship. 10/8/26.
This is FOXO.
Yes.
So let us appoint an amicus. As per office note, service report is not yet received by the registry. This case has been pending since 17/6/26 for service. Respondents number 22. Petitioner has been behind bars for more than a year. Having regard to the above, body is present legally. Brown is there, all right. Appointed as amicus curiae to represent respondent number 6. Copy of the petition served upon her. Is the matter again on
26.
Please, your lordship. Lordship, my senior could not appear. Lordship, may kindly pass time. Oh, sorry, for the day.
prayer of learned counsel for the petitioner list again on
Deeply obliged, lordship.
Can have after some time, Lordship, RJ Borua will appear in this another court.
Please, lordship.
furnish. You have not received at all. To take up some other day.
Taken after some time, lordship.
After some time, good enough for you. No, no. You haven't gone through it.
84 days behind the bar.
84.
Yes.
And why have you not served copy? Last order, it must have been mentioned. It is your fault.
But the contact number,
What?
the number of the.
You don't have the contact number.
Either from anywhere.
Huh?
It's the most easiest thing.
Friday. Then. Because query for respondent number 2 submits that copy has not been served upon her. Can be served upon her in the course of the day. Is the matter again on Friday.
Please, your lordship. But I am appearing as legal aid counsel, my lord. This case, my lord, this is a old pending case, my lord, because my lord wife, my lord now respondent filed a case before the learned CGM, my lord Hailakandi, seeking maintenance allowance, my lord, for herself and her minor son and her only son, my lord, daughter. My lord, in this case, my lord, that case, my lord, learned CGM, the Hailakandi dismissed the petition, my lord, and against that order, I have filed a criminal evasion learned session just Hailakandi, in which case, my lord, after hearing the parties, the learned session just passed an order and directed the petitioner, my lord, to give the 3,000 maintenance allowance, including the arrear amount, this from the date of passing the order, that is, my lord, 9/1/19, my lord. My lord, in this case, although after going through the evidence, your lordship will find that although there was no
formal marriage, but my lord, it's a fact, my lord. 3 PWs were examined at the lower court, and it's very much clear that, my lord, both the parties had had love affairs, and she lived as a wife at his petitioner's house, my lord. And after that, she became pregnant, and child was born. So, my lord, it's a provision of the CRPC that my illegitimate child, although they claim that no marriage was performed, it's a provision, my lord, CRPC that, my lord, illegitimate child also is entitled to get the maintenance, my lord. And my lord, in the lower court, my lord, the petitioner had not filed to do the DNA test. Prove the fact that he is not the father, my lord. DNA test is mandatory, my lord. They have not given any prayer that he is, no, she is not the wife, she is not the child of that father, my lord. Learned lower court, my lord, passed the order. Learned lower court passed the order, my lord, very wrongly, and against that order, learned session judge rightly passed the order, my lord. He is a able-bodied man, my lord. Petitioner is able-bodied man, and monthly income, he is, my lord, more than 20,000. He is able-bodied man, my lord. There are
I think
sufficient-
challenge is only regarding the marriage.
No, my lordship. What challenge, my lordship? Page 14 may be seen, my lordship. My statement, my lordship. The second party also stated that page 3 of the judgment, my lordship. Page
Yes.
14. My lordship. Second party also stated that the first party earlier got married to one Idris Ali of Lalamuk, and that marriage was also done forcibly by the first party and the last, and at last the marriage ended in divorce. The second party stated that he was implicated falsely in a case of rape by the first party, and he has been has to remain in jail hazard, and the case is pending trial presently in the court of Honorable Session Judge Hailakandi. Second party denied that he had any sexual intercourse with the first party, and he had also stated that a child was born to the first party, but the child does not belong to him. Overall, the second party denied all the allegations made against him. Now, the session judge judgment, my lordship, I have been acquitted, which I have annexed, my lordship. Page 30, annexure 4, my lordship. That judgment also, mother of the second party has stated, page 34 may be seen, my lordship, page 34. Page 34, para 7, my lordship. PW3 Koitul Bibi is the mother of the victim. She also filed the Azahar of this case. Her evidence goes to show that her daughter, that is victim, was given marriage with Idris Ali about 4 years ago. But subsequently, the said marriage was dissolved. Thereafter, accused Rafiquddin established relationship with the victim and took her to his house. The other two accused person assaulted the victim girl. She gave bizarre, but matter was not settled. Accordingly, she filed Azahar with the police. So all those facts about her earlier marriage, everything was suppressed when she filed the 125 proceeding, my lordship. Presumption, my lordship, cannot be drawn, my lordship, when I have denied, my lordship. She has to establish it from the facts and circumstances. Her statement, which I have annexed, my lordship, goes to show that, my lordship, annexure 2, page 18, my lordship. She was already 2 months conceiving at that time, and in that imposition, she did not disclose her earlier marriage, my lordship. So I totally denied any having any sexual relationship with the second party, my lordship.
Lord, kindly come to page number 33, my lord.
Just a moment.
The case is that, my lordship, when I have totally denied the allegation, my lordship. It, Honorable learned trial court, my lordship, could have sent for DNA testing, my lordship.
So it was the finding of in another case, Sessions case, that he had not married her. He was convicted.
Yes.
You are convicted.
Not convicted under 376, my lordship.
Cheating. 417.
417.
Mhm.
417.
Mhm.
To marry her, my lord. See, the sexual relationship was going on several times, my lord.
Issue is, my lordship, whether presumption can be drawn, my lordship, when I have denied the parentage, my lordship. That is the only issue, my lord.
Where is the appellate order?
Appellate order on page 22, my lordship. Here, my lordship, page 27, the Honorable Session Judge, my lordship, has opined that the second party did not challenge the paternity of the child by bringing cogent and reliable evidence, my lordship. When I have denied, my lordship, so presumption, my lordship, does not rest in me, my lordship. And there is no marriage, my lordship.
So the maintenance is allowed only for the child.
Yes, my lord. Not for herself. On the illegitimate child is entitled to get the maintenance, my lord. There is sufficient ruling regarding this point, my lord. And DNA, without going through the DNA test, my lord, how you can prove that he is not the father of that child, my lord? The vital point, my lord, regarding the point of paternity, my lord. And he is a, my lord, survival of the child, my lord, is very important point, my lord. So, my lord, learned session just passed the order very lightly, my lord. In this regard, my humble submission is this, my lord. Kindly allow him to give the maintenance allowance since the date of passing the order, my lord. My humble submission is this, my.
Yes, who has furnished this?
The recent judgment, my lordship, which I am relying, my lordship. Lordship, I have come with
Para?
my lordship. It's regarding presumption, my lordship, section 112, my lordship.
Yes, what do you want to submit on the basis of the judgment?
My lordship. Well, presumption cannot be drawn, my lordship, on 112 that I am the father of the child, my lordship, when there is no marriage, my lordship. And I have come with the invoking inherent jurisdiction of the Honorable High Court, my lordship. I am ready for DNA testing, my lordship. That if the Honorable Court is pleased to send back the matter and allow a DNA testing, my lordship. Therefore, I have invoked the inherent jurisdiction, my lord.
Should have been your first submission.
Because I have denied, totally denied, my lordship. And she has suppressed her earlier marriage also, my lordship. It is very much evident from her statement, my lordship.
All right.
My lord, only one thing, my lord, I beg to submit, my lord, to submit one ruling.
Do you have any objection to DNA testing? It is your complaint that he did not ask for DNA testing. So if we allow DNA testing, do you have any objection?
Yes, my lord, but at this stage, my lord, that question does not arise because at the time already, my lord, at the time of the giving, recording the evidence and at the time of hearing evidence and my lord, at the time of hearing argument, my lord, the question arises at that time, my lord. My lord, this is the whole pending case. The occurrence took place on, my lord, 6/19 and this is 26, my lord. After lapse of time, my lord, how the question arises at this stage, my lord?
My lord.
At this
She
stage, my
suppressed
lord,
her
Supreme
earlier
Court
marriage,
ruling
my
clearly
lordship,
says-
all along, my lord.
Amended Supreme Court ruling, my lord, clearly says that, my lord, 2021, my lord, application for the amended section 125 reads as under order for maintenance of wives, children, if any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, his legitimate or illegitimate, my lord's child, whether married or not, unable
Question of legitimacy is different from the question of paternity.
Lord.
So
My lord, at this stage, my lord, occurrence took place, my lord, she has filed a maintenance case seeking maintenance, my lord, in the year, my lord, 2019, my lord. Not 2019, my lord. 2015, my lord.
it is a child born not out of wedlock but outside of wedlock. So prima facie child is to be termed illegitimate under 125. So he is otherwise entitled to maintenance.
My lord.
But if the paternity itself is disproved, then who is liable to pay maintenance?
My lord, that question arises at the time of filing this petition, my lord, 2015, my lord, respondent has filed this petition seeking maintenance, my lord. And now, my lord, 2026, already session court, my lord, session judge is directed to give maintenance 3,000 only, very less amount, my lord, for child.
But if it is not his child, why should he pay?
My lord,
If it is not his child, why should he pay?
my lord, that is not clear after going through the evidence and
Why should we not make it clear now by DNA test?
humble submission is that it's a very clear that it's a vital point not to establish the case that he is not the father of the child. DNA test not examined in the year 2015. They have not given any prayer also.
All right.
For
Yes, we've heard you.
so my humble submission is that kindly allow him the maintenance. Highly obliged, my lord.
Highly obliged.
Service.
Wait, is a rush. Yeah, they have come for cancellation of the bail, lordship.
Filed by the state.
The order Lordship will find on page 37.
Yes,
of
let
the-
him move where he has come for cancellation.
NDPS matter looks, which will 37, annexure 8. This is the order. Technical ground lordship, non-compliance of 48. Find it at the third paragraph lordship. However, as far as the lordship is,
Is it not filed before that court itself? Cancellation can be by the same court. This is not an appeal.
Yes, Lord.
there is no,
Under which provision this is filed?
there is no bar as such.
Hmm?
483 lordship.
For 83 subsequent.
All right. Yes, what is wrong with the order?
Kindly order at page 37, annexure 8. Lordship will kindly come to the fourth paragraph. However, as far as Lordship is found it. However, as far as the compliance of section 48 on perusal of the said notices, it is seen that with regard to the notice issued to Anwar Hussain, the recipient of the said notice is one Jahrul Singh of Borpeta. And as per the endorsement given by the IO, it reveals that he was nominated by the accused and that he had undertaken to transmit the said notice to the wife of the accused. The same cannot be taken to be due compliance of the provision of section. Next, Lordship, the paragraph Lordship, with regard to section 48 notices issued to relatives of Aminul Sikdar. There are two accused persons, Lordship.
Hmm.
It is seen that the
You are
IO
for cancellation of one accused only.
both.
Both.
Relatives of Aminul Sikdar, it is seen that the IO has made an endorsement that the said notice was served upon Jahrul Sikdar, who was the brother of Sahed Sikdar, father of the accused. However, except the said endorsement, there is nothing on record that would in any way show that Jahrul Sikdar was related in any way to the accused or his father. That being so, the said notice under 48 Aminul Sikdar cannot be said to be in
Yes.
Now, Lordship will kindly come to page number, Lordship, 23.
Yes.
23, Lordship, this is the bail application which was filed there, and it was for both the petitioners. Just seeing that, Lordship, will kindly come to page 24, first paragraph. I begs to state that accused number 1, that is Anwar Hussain, is his friend, and accused number 2, that is Aminul Sikdar, is his brother, and the accused person are citizen of India residing in so and so and so. And Lordship will kindly see the affidavit page. At page number 12, 34, Lordship. Jahrul Sikdar.
So accused number, in respect of accused number 2,
Yes, he's
the
brother.
48 notice was served on this Jahrul Sikdar.
Yes, yes,
Who is the brother.
yes,
And in respect of accused number 1, it was served on his nominated person.
yes. Same person, Lordship. He put the petitioner. He acted as the representative of Lordship. Our ground, Lordship, court, Lordship.
Yes.
Lordship, the arrest has to be made as per Sanhita, Lordship. The 36 notice kindly Lordship, peruse Lordship, that notice. Whether
No, we are not going to 36.
because Lordship, what happened, Lordship? At the time of arrest, this person was not nominated since that's why Lordship, he has not put signature in the notice also, Lordship.
That
that is their.
That was not the ground on which you have been granted bail.
Lordship, this kindly see the lordship, only because of this affidavit, lordship. Only because of the affidavit, they have come and said, lordship, and these two accused person, lordship, not from the same place, lordship. Kindly see that, lordship. PS is different, lordship. Two person from different place, lordship.
No, you confine your answer to the ground that has been given here.
But lordship, he is not the relative of, it is his statement, lordship, Anwar Hussain. But he said, lordship, why he has informed to his wife, lordship, Anwar Hussain wife, whether wife has come or not, lordship, that has to be scrutinized, lordship.
No, this Zahirul Islam.
Zahirul Islam say he is a friend of that Anwar Hussain.
Yes.
I'm not for lordship, I'm not arguing on behalf of now at present lordship, Aminul Sikdar. I'm for Anwar lordship. So notice is not served to this Anwar lordship.
Statement, lordship.
That's why court below has rightly find lordship come to the conclusion, lordship, it's the notice has not been properly served.
Where is the nomination? That he was nominated by.
That lordship will find it at page 21. Lordship, can you
In the record, lordship, can you pay this?
page 21, lordship?
Yes.
But in 36 notice, his name is not there, lordship.
The application was filed by this.
Zahirul Sikdar.
Huh?
Zahirul Sikdar.
Zahirul Sikdar. Yes, on that basis he is granted bail. Then you are saying you don't know him,
But
and he has filed on your behalf.
The things is that lordship in the notice, probably his name would be there, lordship, if he is nominated by this person, lordship, at the time of arrest, lordship. In presence of, at the time of arrest, he has not put his signature, lordship.
How can he be the nominated person? How can he
And
put his signature?
That lordship has to be arrested in presence of the lordship, either
We are not
in the
going there
relative
now.
or lordship.
Your bail is not
respectable-
granted on that ground.
Respectable member of that family, of that locality, lordship.
Your bail is not granted on that ground.
That is not on the challenge.
Bail has been granted, lordship, whether now the lordship violation of the condition is arise, lordship. Now, rightly or wrongly, lordship, the court has passed that order, lordship. Let the matter be sent back to the particular court to appreciate this matter, lordship.
For cancellation of the order, lordship, and already the order has been stayed, lordship, if I'm not wrong.
Wait for the time being, lordship. Have to be considered.
So they are still in jail.
Yes, lordship, still in jail.
Cancel, lordship. And the NDPS matter, lordship, all technical ground it was granted, lordship. When the technical ground goes, lordship, section 37 will automatically come.
But now, even as per Rajesh Mir's,
Before
you can again give follow the proper procedure. You can apply to the magistrate, follow proper procedure, arrest him again. There is no necessity of cancellation also.
that does not Lordship, because the technical ground was taken, that it was not given. Whereas on the record, it is seen, Lordship, that there is an apparent error.
And about the other fellow who is appearing, you are appearing.
I'm appearing, but on that regarding notice and 48 Lordship, I'm arguing on that. Regarding the Lordship, other accused Lordship, it's okay, Lordship. It is up to the petitioner Lordship.
All right.
NDPS, my lord. Petitioner is a lady registered owner of the vehicle, my lord. She is not named in the FIR, and her son was arrested, released on bail. Now she got a notice in the charge sheet. She was shown absconder. Only materials against her, my lord, page 37. For FIR is concerned, FIR is page 19, my lord. Page 19. For the present petitioner is concerned, 37. That during investigation, your lordship kindly see only one line, my lord. Yes, third paragraph, my lord. Page 37, third paragraph. During the course of investigation, the owner of the seized vehicle was identified as so and so, so and so, so and so. That much, my lord.
There's also one paragraph is there.
Huh? Or after that. The same paragraph continuation. Yes. According to notice so and so, so issued, owner did not appear. So she was shown absconding, my lord, and now she will receive notice, my lord. She will appear, my lord, and nothing for no whisper against her in the FIR. Except this point.
There in the charge sheet.
Yes, charge sheet absconding, my lord, page
37.
Page 37. Paragraph, third paragraph. This paragraph is the only materials against her, my lord. Other than sorry, also, if I look here, page number 1. I'm not here.
Is he related to any of the other co-accused?
Yes. Lordship will kindly see down below. Name of the accused appears, Lordship. Petitioner is petition number 4, accused number 4, wife of late Fulmia. And Lordship will see the accused number 2.
No, she is not named. She is not named in the FIR.
Investigation, she was.
No. Charge sheet, yes.
She is wife of Fulmia.
Yes.
He is late.
Yes. And Mamun Mia is the son
Son of the present petitioner, right?
Son of Fulmia.
Son of the petitioner.
Lordship, let us examine. Let this pen copy come, Lordship. Already charge sheeted.
The meantime, I will appear, my lord. Your lordship, simply I am the owner. My son, they are already arrested, my lord. They got bail. They are on bail.
Based on
All the persons arrested, my lord. FIR known persons.
What is the urgency? You have about the investigation, you have been at large.
Only my lord has been asked to appear.
Then
Notice as it all.
someone was
Someone was issued, my lord.
investigation
we'll see here because commercial quantity, is it not?
commercial quantity.
Yeah.
37 is
No, that is there, my lord. Whether my involvement is there or not, I am only on that.
Can teacher will leave it.
Can copy, yes. It is here.
8, my lord. A lady, my lord, 70 years. Registry. 28 August. Obliged to.
Yes, my lords. It be taken up, my lord, tomorrow, day after tomorrow, my lord. I've not been able to go through a scan copy of the record. My lord.
Tomorrow?
Tomorrow. My lords.
Just again tomorrow.
Yes, my lords.
It is your lordship. NDPS, your lordship. FIR at base 12, your lordship. Charge sheet laid, your lordship. Record was called for. Lordship. 4 months, 18 days, your lordship, behind the bar. 21B, your lordship, intermediate quantity, your lordship. He was arrested on your lordship.
Covered from his house, lordship.
I strongly believe that it has been planted, your lordship, by someone, your lordship.
Adler, lordship.
11 grams.
11 grams, your lordship. All the witnesses are official witnesses, your lordship. Charges has been laid, your lordship. Not the trial will start, your lordship. Will appear before the court.
Hard learned counsel for the petitioner and learned LPP. This is an application under so and so. The allegation against the present petitioner is that 11.25 grams of suspected heroin was recovered from his house on 25/3/26. Accordingly, the petitioner was taken into custody. The case relates to intermediate quantity and the investigation of the case is also over, culminating in a charge sheet. Petitioner has been in detention for how many days?
Your lordship, 140 days, your lordship.
140 days. And in regard to the period of detention and completion of investigation, prayer for bail is allowed. 50,000 to securities. Cooperate with the trial if one commences.
They oblige, your lordship.
Lordship.
Yes, TCR is here. is it? No.
No, lordship.
His diary has not yet been.
Charge submitted.
What is the offense? POCSO.
This year will be there.
POCSO.
Oxford, lordship. Service also complete.
Service complete.
Service complete.
Alternate counsel for the petitioner.
Should I request you to amicus?
Alternate additional PP submits that service. The respondent number 2. Case has been charge sheeted. Call for the scanned copy of the TCR. Appeared on behalf of the respondent number 2. So and so is appointed as amicus.
B. Sharma may be appointed. MS B. Sharma. Amicus. She is appointing?
Yes,
MS B. Sharma. Lord.
amicus. Copy of the petition be served upon her. Again, no?
Charge number? Charge number CS number 16/2026 dated 30/7/2026.
Lordship, the matter may be listed on 19.
After received the scan copy. Lordship, regarding section 50, Lordship. My friend was saying about, learned friend was saying about section 50, Lordship.
Yes.
Like rule 50, Lordship. Section 50 can be invoked only in the case where the drugs, narcotic, and DPS substance is recovered as a consequence of the body search of the accused. In case the recovery of the narcotic is made from a container being carried by the individual, the provision of section 50 would not be attracted. It is recovered from the bag, Lordship. And regarding this also, I have cited one citation, Lordship, para 12.
Where is the recovery in this case?
Is from the bag, blue color bag, Lordship,
But carried by the accused.
carried by the accused person. As in Baldev Singh also. Accused was also informed that he was to be charged, Lordship. The procedure was explained to him, Lordship, before charge. After calling the independent witness, Lordship.
Yes, but recently, another judgment, I forget the citation, it says that even if the recovery is made from the bag,
Lordship.
but search is made on the person, search of the person is made, then 50 has to be complied with.
But he was explained about that, Lordship.
I
Section
have already given this judgment.
50 was explained to him and the independent witness.
No
with-
notice of under section 50.
Permanent.
Permanent. Rajasthan versus state of Rajasthan versus permanent.
Yes, yes,
And
in this
others.
case only. it
And
was given.
also, criminal appeal number 28 of this honorable court was first. Already started. I have submitted.
Now, in the present case, question was whether any section 50 notice is available in the record.
It is not available, but he was explained, Lordship. He was explained about the terms, Lordship.
In this case that you have submitted today,
Lordship,
Mehboob Shah,
Lordship.
here no search, this search of the person was carried out after he was informed of his right.
In this case also, Lordship, it is while Lordship.
No, here, no, informed of his right, and the document has been report of the grant of consent, exhibit P1, that was exhibited. That is the document we are asking for.
It is not available, Lordship. Record, it is not, I have not gone through the document. It is from his position, Lordship, it's a commercial quantity. Evidence of independent witnesses are there.
Could the independent witnesses say that you were informed of your right, he was informed of his right?
Lordship, they have said, Lordship, in the, that before Charles Lordship, he was, they were explained about it.
I don't think independent witnesses have said that.
About the accused, they have not said, but they have said that the police have explained to them about the charge and seizure in front of the.
That's hardly relevant.
That is-
Whether section 50 was notified to the accused, that independent witnesses, I don't think they have deposed to that.
Body weight charge, that is there, Lordship. One VDP secretary, one VDP member.
Everything is fine, but section 50 has been consistently held to be mandatory. Even if recovery is from this
From his position.
bag, then section 50 is not required to be complied with, be provided the person, if the body of the person is not searched. But if the search is carried out on the body, and even if nothing is found, then also section 50 is mandatory as held in permanent.
His recovery from the.
Whether you agree or disagree with the reasoning, that's a different thing, but that is the.
From the bag of the.
Yes. So it is very specifically said in permanent, even if recovery is from the bag and search is made on the body, then section 50 has to be complied with. Yes, okay, we'll pass orders.
No, the service report is not received, man. Scan copy is.
And copy of TCR received, but service on respondent number 2 not yet. Again, next week.
Yeah.
Get instruction.
May I please, Lordship? Lordship, kindly peruse the last order. This honorable court, Lordship.
Yes. Not received.
Not received, my lord, case diary.
Waiting since February. It is the FIR, Lordship. But I am fully cooperating with the investigation, Lordship, for the time. Commission, Lordship, interim may make absent.
What is this about medical practitioner?
My lord, in fact, he is a pharmacy.
My lord, I'm sorry, my lord. In this case, my lord, the matter was the day before yesterday, my lord. Then we have to obtain the instructions whether, my lord, why the case diary was not sent, my lord. Then we have received the information, my lord, already searched it, my lord.
I will cooperate with the trial, Lordship.
Can appear there now.
Trial repair.
Eh?
And the interim may make a
No, no.
repair. I am fully cooperating with that.
We have to make it absolute. We have to call for the TCR. What is the charge against you? Let us see just once. What is the
Others, my lord, criminal breach of trust, my lord. He wants
Only criminal breach of trust. Other sections are available. Criminal breach of trust, lordship may extend to 5 years or fine or both. Business is rivalry, lordship. In fact, he is a pharmacist. I have annexed the license of the pharmacy.
Oh, it's a old FIR, I think. This I remember this. Several, I think, these fake doctors were arrested. This Abhijit Neok, the informant, I think. Where is the FIR page?
Lordship, page 20. 20.
Yes, it's lodged in October 25.
Yes.
Your name is Rahimuddin.
My lord, Razimuddin.
Huh?
Razimuddin.
Razimuddin.
Pharmacy.
Any earlier application was rejected?
No, this is the first application.
FIR looks familiar.
It's 33 is the license. The petitioner. Terms and
What
conditions.
to do now? Yes. He's under interim protection.
Yes, lordship, since
by humble submission, my lord, since Harshid has been submitted, my lord. Let him appear, my lord, and his interim may be, my lord, extended till his appearance. My lord.
Yes.
First, my lord, we have to my lord, use the scan copy of the case diary.
He appeared there. Till then, we'll protect you. Otherwise, if we have to.
Otherwise, lordship, I have fully cooperated with the investigation since February. As and when lordship called, I appear. And in the trial, lordship, with stringent condition, lordship, I will appear regularly, lordship. That condition may be imposed, lordship. Long time he was in interim.
Assuming the allegations are true, he was functioning as a fake doctor. He'll have to face the trial where after investigation, I don't think any purpose is left in taking him into custody now for the trial. It's of heinous offenses, of course, we take a different view. I heard learned counsel for the petition and learned additional PP. An application under learned additional PP that the case has culminated in charge sheet. The allegation against the petitioner that is that he has been earning as a medical practitioner without possessing any degree, any medical degree. Pursuant to interim protection granted by the court, it is that the petitioner has been cooperating with the investigation, which is now complete. The case is ready for trial. Having regard to the above as well as the nature of the allegations, be necessary to take the petitioner into custody. In interim during the course of the trial. Accordingly, the prayer for pre-arrest bail is allowed. The order of pre-arrest bail dated so and so 13 to 26 is hereby made absolute. The condition that the petitioner shall cooperate with the trial as and when it commences.
What we also might have searches submitted, my lord.
Yes.
With here before the trial court, Lordship. We are in interim protection. We have appeared before the IO. We were on interim protection and we have appeared before the IO, Your Lordship. PD was called for that.
Is the allegation here?
Your Lordship, 3 to 4 friends, they came to Gauhati and then they rented a car, Your Lordship. Thereafter, that rented car was kept in one of their houses and they were demanding money from the person whose documents were used to rent that car. Thereafter, some altercations happens between them and the police recovered the vehicle. The vehicle has been returned to the original owner in Gauhati, that is a travel agency. Thereafter, one person was granted anticipatory bail. 2 were in custody. They were also granted bail. He is one of the person who is identified as the friend who took him to Gauhati to the travel agency to book that vehicle on rent, Your Lordship. While on interim protection, we have appeared before the IO and recorded our statement, Your Lordship.
Your name is
TL Oscar, Your Lordship.
eh?
TL Oscar.
No, we are the petitioner.
Petitioner is Shairu Falum, Your Lordship. Petitioner number 1. Accused person number 1 in the FIR, page number 13. The car was not recovered from me. Nothing was recovered from me.
Learned counsel for the petitioner and learned under so and so. The allegation against the petitioner is that Para 2, huh? Para 2 of the bail application. Course of investigation, the two of the accused persons were arrested. Frequently, they were released on bail. The present petitioner, to his pursuant to interim protection granted by this court, has appeared before. Statement was recorded. Also submitted that the vehicle in question has been recovered and handed over to the government owner. The investigation of the case has been completed and chart submitted. Having regard to the above, it necessary to take the petitioner into this stage. Frequently, the prayer for pre-arrest bail is allowed. 8526. It hereby made absolute.
Deeply obliged.
This petition is an apprehension of salmon minor. The learned judicial mistake first class. This case, my lord, in the year 2024, my lord, an FIR was lost by the mother of a daughter, saying that there was a lab FIR, so it me a daughter, my lord. And accordingly, 2 persons were arrested at that time, and absconder charge sheet was filed, my lord. Now my humble submission, my lord, I am ready to face trial, my lord. In fact, my lord, nothing ingredients against me. Only there is a lab affairs, my lord. The victim girl was refused to medically examine.
Now what has happened?
Yes, my lord, now someone is issued to me, my lord. And I filed anticipatory bail application before the learned additional session judge, which was rejected, my lord. That is why I am before your lordship, my lord. 366A is the, my lord, section under which cognizance was taken, my lord. Page 30, my lord. To copy.
Elopement case. Elopement case, basically.
Development case, my lord, but in the search matter, he has been shown absconder, my lord, then trial court, no, so we have. Trial court, my lord, issued summon, my lord, but he has not appeared, my lord.
Naturally,
Bail
naturally, he'll be put in
bail
behind
application.
bars. I'll learn a counsel for the petition and learn it. Forty-three. Petition and learn it. Then application under so and so. Effects of the case are victim who was aged about 16 time of occurrence was taken away by the accused petitioner. While she was on her way for her tuition on 08/06/2020. Subsequently, he was recovered about 3/4 lodging of the FIR. The investigated charge sheet has been submitted. Received summons. Apprehends arrest. The appearance before the court. Perusal of the statement of the victim recorded by the magistrate indicates the present one to be a case of elopement. Of a love affair between the victim and the accused petitioner. A sheet has been submitted under section 366.
366 A/34. A/34.
Yes, 34. Against the present petitioner. There's no evidence. Other two co-accused. Named in the FIR. Having regard to the of the allegations and the fact of completion of it, there appears to be necessity of petitioner being taken into custody. Age. Accordingly, prayer for prayer. Interim is there.
No, right.
Direct. His arrest shall be released on bail of rupees 50,000 with a security for like amount to the said trial court. Where is the case now?
Now, my judicial magistrate first class.
Plus,
Committal stage.
is it committed?
Not committed.
Not committed matter.
So you'll have to appear there.
Cognizance taken.
Then allowed accordingly.
44.
No, my lord, investigating officer has paid for some time to produce the case diary.
There is an interim order.
CD not received. Again, also and so interim to continue till the next.
27 or 28.
Yes.
Well,
27. My lord, POCSO case, my lord. Service is complete, my lord, but we have not received the case diary, my lord.
Second time, Your Honor. Please.
Body appearing. Third learned counsel for the petitioner. Learned additional PP service is complete, but none appears. Order respondent number 2. Accordingly, so and so is appointed as MIS to represent respondent number. Yes, called for is not. Would like you write extra copy be served upon the newly. Been received. Interim order first. Next date of listing. List again on.
Petitioner number 2 and 3 is in there.
Huh?
Petitioner number 2 and 3 on interim lordship.
One is not. 2 and 3. We have only said interim order, whoever is relates to.
Obliged.
They are appearing. Third learned counsel for the petition and learned additional. And so learned counsel. Yes, for respondent number 2 and praise for some time to file objection. Scan copy received.
Scan copy not received, my lord.
Scan copy of TCR not received. Issue reminder. Again on.
Your Lordship. Lordship, earlier case diary was called for. The implication is that, Lordship, I was at that relevant point of time, I was the vice chairman of a company, SBL Knowledge Services Private Limited. And we as a company, Lordship, we applied for the tender and we also got the tender also, my lord.
Who are you?
I was
Manoj Jacob.
Manoj Jacob, my lord.
What were you?
Lordship, may kindly come to page number 14, the relevant part of the FIR concerning the present accused person, my lord. That then
He was the vice president, my lord, regional head of the my lord company, my lord.
yes, Lordship. It was the allegation that subsequently some additional documents were submitted to get the tender, which were allegedly forced, my lord. But at that time of making application for the tender, we have submitted the original documents that we admittedly, Lordship, we have submitted, but subsequently who has submitted those additional documents that we are not aware, my lord. Lordship, may kindly Lordship, page 14, my lord, the relevant paragraph starts with the then PDAF APFBC, Lordship, got, my lord.
Yes.
Then PD APFBC, namely Shri KSPV Pavan Kumar, sought for additional documents from SBL Knowledge Services Private Limited on 30/4/2022. These documents were submitted by Shri Manoj Jacob, Vice President of SBL Services Private Limited, with a forwarding letter dated 6/5/2022. There were discrepancies found in the date of documents. SBL Knowledge Services Private Limited had submitted experience certificates from State Bank of India and Nagaland Police as supporting documents of their experience in supplying vehicles. However, SBL
So you had submitted the additional 3 documents.
Lordship, those documents, some
4 additional documents.
Yes, Lordship, in my name, my lord, by forging my signature, these documents were submitted, and I was the first person to make a complaint regarding this to the police, my lord. At page 16 is the complaint submitted by me, Lordship. Otherwise, Lordship, I have appeared before the IO. I was put to notice for appearance, and I have recorded my statement also, my lord. I am already cooperating with the investigation, Lordship. Lordship, I am relying on an authority of the Honorable Supreme Court also regarding the, since the case is primarily based on documentary evidence, Lordship, therefore custodial interrogation may not be required, my Lord. May I pass on a copy of the authority, my Lord?
Yes, what is there, PP?
Voluminous case diary, my lord. So I am placing this objection of the investigating officer, my lord, in a nutshell, my lord.
I have appeared and recorded my statement also, Lordship. I am cooperating with the investigation, my Lord. On 2 dates, I have stated in my petition, paragraph 6, my Lord, paragraph 6. On 2 dates, I have appeared, Lordship, paragraph 6. Petitioner has extended his full cooperation with the investigation, having appeared before the investigating officer
His
on
nutshell
16th.
is also voluminous.
Investigation is going on, my lord.
Lordship, I am cooperating, my Lord. I may be protected, Lordship. I'll extend my cooperation, Lordship, as your Lordship may impose terms and conditions as your Lordship may deem fit, Lordship. And I'm relying on a judgment, Lordship, Pradeep and Sharma versus State of Gujarat, Lordship.
Any statement of his there is there?
That time, my lord, found his statement, my lord.
All right, you hand over the case there, you will see then. You first go through it.
Yes.
2 accused persons are already enlarged, my Lord.
Where is the order?
1 and 2. Lordship, on during motion hearing, Lordship, I have submitted, but today I am not available with the orders, Lordship.
Yes, my lord, he appeared, my lord. He appeared, my lord, once, and he was again directed to appear, my lord, for further investigation, further examination, my lord.
2 dates, on 2 dates he
The
has
note of the
appeared.
investigating officer, my lord.
Huh?
The note of the investigating officer, my lord, in 7/2026, my lord.
He appeared.
He appeared, my lord, and after examination, he is allowed to go with direction to appear whenever required for further examination, my lord.
So why is the IO now
Question
seeking
is why is
custodial?
apprehending, my
Huh?
lord? Question is why he is apprehending, my lord? After 67, my lord, whether my lord, he has received any kind of further communication directing him to appear, my lord.
Why he is apprehending answer is given by IO. He is objecting to the pre-arrest bail.
But, my lord, question is that, my lord,
That is the question. If he is
not taken
appearing,
into
he has been
custody,
questioned. Why is the IO?
while
In
he
view
appeared
of the facts and circumstances, it is respectfully submitted to move the Honorable Court for rejection of the bail application. Strongly oppose the grant of bail. That is his apprehension.
But, my lord, while he appeared on 67, my lord, he appeared without any protection, my lord.
Yes.
Just for the sake of cooperating with the investigation, Lordship, I have extended my cooperation, my Lord.
I'll take instructions, my lord. Let the matter come up on Friday.
And since I have appeared, Lordship, I may
So
be
since he has
protected.
appeared, my lord, so I'll.
He has again called by the IO, Lordship, to appear at a convenient time, Lordship.
The fact that, my lord, he appeared without any further protection from this honorable court. Was, my
It
lord,
was put to notice, pursuant to the notice I have appeared, Lordship, that notices I have also enclosed, annexed with this petition, my lord.
All right, you pass on the CD. But what instruction, everything is there. Don't think further instruction is.
That is from the note of the investigating officer, my lord. There are some discrepancy, my lord, from the tender process onwards, my lord. And regarding, my lord, bank guarantee also, my lord, there are some manipulation, my lord.
That we have seen.
Yes,
That is undoubtedly there. Foul play is definitely there, no doubt about it. But
My lord, regarding the
regarding, we
custodial-
are concerned with the role of individuals and
My lord.
particular individuals and the necessity of their custodial interrogation at this stage. Yes, next.
Otherwise, Lordship, the entire case is based on documentary evidence, Lordship.
Earlier bail order is not with you?
Lordship, this is my first application, Lordship. And
No, co-accused.
in respect of 1 and 2, Lordship, at present, Lordship, I am not available with the orders, but during motion I have submitted to the court. I am not aware if it is in the record, available in the record or not.
All right. Yes, next.
Right.
Please, Lordship. Lordship, 482 application, Lordship. And the FIR, Lordship, will find at page 10, Lordship.
What is this, the item number?
Item 59, Lordship.
59.
His diary was called for, Lordship.
Yes, there is there, Lordship.
Page 10, Lordship, the FIR, Lordship. May I read, Lordship?
Yes, where is the statement?
164, Lordship.
Yes.
I am not for accused number 1, Lordship. I am for 2, Lordship.
For whom?
For 2, Lordship.
Who is he?
He is a VDP secretary, Lordship. The allegation against him, Lordship, the other accused persons, Lordship, that they have deleted one video, Lordship. What video? Actually, as per my instruction, Lordship, no such video was there, Lordship.
The video, Lordship. So the video only her mother came to know about the incident. Fire was lodged only after knowing of the incident through the video, Lordship.
So only allegation is against him is regarding making of the video.
Not making, Lordship.
Deleting the video, Lordship.
Deleting.
The evidence, Lordship. Because she was minor, Lordship, at the relevant point of time.
This is absolutely a false allegation.
What is the name of this Jonab?
His name was Riazuddin, Lordship.
The one whom she had-
No, he says I went. Jonab called me to sweep the floor. She went there. He was not there.
with whom she have the relation. And petitioner is Najar Ali, Lordship.
Since the occurrence, Lordship, alleged occurrence is with regard to a masjid, Lordship, in a madrasa, Lordship.
Who is Tajmul? That is what she says.
Not Tajmul.
Her Lordship.
183 statement. মই তাৰ কাষত বিছনাত বহি মোবাইল চাই আছিলো তেনেতে তাজমুল আহি আমাৰ ভিডিঅ' বনাই
Tajmul is one of another accused, Lordship.
No.
No, he is not the accused. Lordship, in the Azahar Lordship, may see Lordship, the second part. I came to learn about the said incident today after watching the video. It is pertinent to mention that the accused number 2, 3, and 4 knew about the heinous act of rape committed upon my daughter, and after watching the said video, they deleted it and instructed not to report the matter to the police. This person, Lordship.
This is an allegation, Lordship. Now, if Tajnur has made a video, Lordship, he should have made a statement also.
There is no video.
It was deleted, Lordship. So there was no video.
So how are you going to prove it? What is not there?
That is there, Lordship. Photograph.
Here. Viral that 2000. Went to the police station. It's not. In this regard, mother.
According to IUA, one pen drive containing the incident has been seized.
Seized.
That is from, I think, secondary source.
Lordship.
The girl herself says that nothing happened.
And the loss complaint also, Lordship. He has annexed this complaint here. I'll cooperate, Lordship, with the industry.
In 160, 183, she have not implicated. 183, she have not implicated the accused.
That is a different, actually, that
That
deleting of the video part, she would not know. So she cannot implicate, the victim
Lordship.
cannot implicate. There has to be some other. Sense, I think.
So the video viral, mother came to know and she lost the affair.
If it was viral, then it should be in the air, Lordship. How can that be deleted, Lordship? It will, if it is viral, it should spread, Lordship.
As per allegation, I am saying, look, and in the pen drive was seized.
Will examine pass orders.
Obliged.
Your Lordship. Lordship, it is a case against acquittal. Section 130 Negotiable Instrument Act.
Come tomorrow. Kali I will eat here.
Lordship, several
Yes.
Lordship, several steps has taken and the maximum step is served properly. But nobody represent the respondents, Lordships. And even, Lordships, the counsel from the legal aid has also appointed by the predecessors. And in 2 consecutive dates, some AK Das has appeared from the legal aid. Thereafter, Lordships, the case is standard like this. There is no progress at all. The matter,
There is only one respondent.
only one respondent, Lordship. Lordship, it is, things is that, Lordship,
But
it
there
is
is
the
office note, I think, saying learned advocates have entered appearance on behalf of the sole respondent by filing wakalatnama. What is there?
earlier, Lordships, counsel from the legal aid has appeared in 2 consecutive dates.
UK Bormon, Mohammed H. Ali, D. Pegu, R. Kuar. The names are reflected. What is the matter?
Lordship, the respondent has admitted during his cross
Okay, this has come for orders then. We'll list it for admission then.
Yes, Lordship.
Third learned counsel for the petitioner. None appears for the sole respondent, although names of learned counsel are reflected in the cause list. This is the matter for admission hearing on date.
Lordship, please take that. 26 August. 7 September. Lordship. Is it 7 September? 7 September.
Please, your Lordship. Lordship, an application praying for amendment of this address of this respondent number 3, my lord.
Third IA
File.
420. Third learned counsel for the petitioner. The application has been filed taking correction of the respondent number 3 as follows. Para 2 of the IA. The prayer is allowed. The address of the respondent number shall stand corrected as above. File amended for title, highest and list
Pleasure, Lordship.
connected matter again on given date. Yes, you write list on 8 of September.
Oh, yeah, I have here 54 logs.
Office to
54 logs. 4 log TCRs. But even then, my lord, for consideration of the bill, I have annexed all the deposition of the witnesses and the relevant documents along with the appeal, my lord.
Yes, Sharma alias Gauhati.
Rightly kept, my lord. Otherwise, it will not be have been 600 rupees per kg for good quality. My lord, your lordship will kindly look into the FIR at page 25. And the original vernacular also, we have given a type copy. Your lordship may look at page 27.
Why is it listed for orders today?
Consideration of the I for bail. 5 years conviction, my lord, absolutely no procedure under 52A followed, cross said, no photography, no videography. Even for forensic examination, my lord, they have sent only 2 bottles out of 114 bottles of cough syrup. It is.
Lordship. Some time, Lordship, because we have not gone to the LCA. I is there, Lordship.
May I please, your lords, item 54 LCS is here, connected metal market.
Connected cap, both. Your lordship will look into the documents because today.
Let them go through if they want to.
Because Lordship, learned friend have legs in some other court, so we too were.
On the last occasion also, the prayer was made.
Yes.
5 years
Last
conviction.
occasion only TCR was called for.
Your lordship will look at the other item also, 54.
54 men.
Both the items are of this, 2 accused are there.
Received in 54 men.
Friday, Lordship.
Had the election as a
Monday, Lordship.
All right. But learned additional PP raised for some time to grow through the LCR. Has been received in connection with appeal 35. Connected to the present. Is the matter again on Monday? 54 also, okay.
On Monday next month. Obliged, your lordship.
Please, your lordship.
Delay.
Yes, what is this for?
For special leave petition for filing a criminal appeal, lordship, against the final judgment and order dated 16/6/125 annexed A page 9 to 26, lordship.
So why not before the session judge? Appeal lies before the session judge.
And he preferred to appeal before this.
You may prefer, we may not prefer. Why should we grant you leave when you can approach the session judge? Why should we burden ourselves when there are so many cases? Is it not PP? Appeal lies before session judge. Why should the High Court burden itself unnecessarily? There is delay also, I think. This is of June 25. Yes, what do you say? What is your submission?
Yes, file for the relief. One shot provision of section 419 of clause 4 of BNSS. Here is the limitation period is for 60 days. But if we see in the limitation act, the 30 days is the limit.
As per limitation act, lordship, 90 days, lordship.
So when did you file?
In the limitation period, lordship. I file on in September 2025, lordship.
(419) BNSS.
Section 4. Lordship, section 419 of clause 5.
Lordship, section 419 plus 4, I have approached before this court.
This is an order of acquittal.
Yes, lordship. Section 4, lordship. 419.
Where is the 90 days?
In limitation act, lordship. Code 114 of
There appears to be a Petition Act says, although it is under the old code, 1898. The similar provision in this code, same. So here it says 90 days. Appeal from an order of acquittal.
চেঞ্জ কৰা নাই নাই কৰা
DNS is still 90 days, 60 days. DNSS is 60 days. This is 90 days. But
section 419
NI Act does not provide any limitation. Appeal.
Clause 5. Clause 5 is no application under section clause 4 of grant special leave to appeal from an order of acquittal set
NI Act condition.
by the High Court after expiry of 6 months. Is a only for public servant, where the complaint is a public servant.
It's 6 months, but other cases it is 60 days. No,
Public servant.
Negotiable Instruments Act.
Public servant. And I see say,
Public servant is 6 months.
yes, Lord.
Otherwise, it is 60 days. But even if you are within the period of limitation, why should I grant you leave?
Complaint. Complainant. Complaint to আমার বিষয় কইছে।
No, the Act does not provide any specific.
Yes, Lord.
Appeal.
And I not provided.
Only provides for power of the appellate court, but not about any limitation of appeal. So we'll have to interpret in favor of the accused. But this is complainant, not the accused. So if we interpret in favor of the accused, it will be the lesser one, 60 days. That question is also there. It is better you file an application for condonation also.
I will file.
That will have to be taken up first.
First, file consent.
Is the matter again on the date after 3 weeks.
Last over.
Well, service is awaited, my lord, so number 2.
This one, respondent number 2 is awaited. List again.
Deep Lord.
This PP, there was I think someone else was there. There was an application for cancellation of bail.
Or Sharma was there.
Yes, maybe.
Next for Jubin Garg.
That cancellation and bail, that application was on merits. This application
Lordship.
committee in the order.
Lordship.
There have been, I think, decision of the Supreme Court that if it is on merit, then an appeal has to be filed.
Lordship.
Cancellation is on ground of violation of conditions and all that. That application can be filed
Then-
before the same court also,
Lordship.
and either High Court or Sessions Court, both. But if it is for if the order itself is bad,
Lordship.
then revision or appeal, some decision is there, I think, the Supreme Court. Just ask him to have a look at it.
I convey them. First steps were taken, Lordship. Service of notice.
None appears for the petitioner. As per office note, first steps have been taken for service on respondent number 2 to OC Dispur PS 23/7/26. But service report is not yet received. Just again on suspension.